Dear viewers, I now want to talk about an interrelated aspect of the Indian judiciary, that is, the role of the Indian judiciary in our constitutional setup. I already pointed out in my last lecture there's the composition and jurisdiction of the Indian judiciary and the role of the Supreme Court are interrelated. Hence, while assessing the role of the Supreme Court, I will refer to the jurisdictions of the Supreme Court already discussed in my previous lecture. I shall confine my discussion into several aspects. I shall try to assess the role of the Supreme Court as a federal court, as a protector and guarantor of fundamental rights, as the highest appellate court, as the interpreter and guardian of the Constitution. Moreover, I shall try to point out a new kind of role described by Rajamani and Sengupta in a recent article as legislative and executive avatar. These aspects has to be assessed also. Hence, I shall try to examine these aspects separately. First, Supreme Court as a federal court. As students of political science, everyone knows that one of the cardinal features of any federal setup is the independence and impartiality of a judiciary to settle disputes between the federating units. Similarly, in India, which as we already referred to as a federal state, here the Constitution distributes legislative, executive, and financial powers to the different units, that means to the central government as well as the state governments. Naturally, there is always the possibility of a conflict, a possibility of a dispute between the central government and the state governments. So the disputes have to be settled and have to be settled by the Supreme Court. As already stated, the Supreme Court in its original jurisdiction settled the disputes between these federating units. That's why the Supreme Court is regarded as a federal court in our constitutional setup. Secondly, the Supreme Court is the highest court of appeal. That is another role that has to be assessed. While analyzing the appellate jurisdictions of the Supreme Court, I pointed out that the Supreme Court has appellate constitutional jurisdiction, appellate civil jurisdiction, appellate criminal jurisdiction. Plus, the Supreme Court has the right of grant appeals on by special leave. So, this power of the Supreme Court in appellate cases is much wider than that of the United States Supreme Court. The United States Supreme Court is considered to be one of the powerful judiciary in the world. But experts are of the view that our Supreme Court's power in the field of appellate jurisdiction is much wider than that of the US Supreme Court. In fact, H.M. Sirvai, a noted jurist, is of the opinion the position of our Supreme Court in respect of appellate matters closely akin to that of the Supreme Court of Australia. So that's all about the Supreme Court's role as the highest court of appeal. Thirdly, the Supreme Court is the protector and guarantor of fundamental rights. Article 32 confers on every Indian citizen the right to move the Supreme Court for the enforcement of fundamental rights. We have an important fundamental right, that is right to constitutional remedies, by which we can move the Supreme Court if we feel that our rights have been infringed or taken away. The Supreme Court accordingly will issue appropriate writs in order to protect our fundamental rights which have been allegedly violated by the executive of our country. So in that case, the Supreme Court plays the role of the protector and guarantor of our fundamental rights. Moreover, there has been expansion of public interest litigation in recent times. So by means of public interest litigation, the Supreme Court tries to protect the fundamental rights of the downtrodden masses, the masses who are not aware of or who do not know how to protect their fundamental rights. In those cases, the Supreme Court has come in the picture, and Supreme Court tries to protect the rights of the poor, illiterate, through the means of public interest litigation. Moreover, Supreme Court, by its liberal interpretation of different provisions in the fundamental rights, particularly Article 21, right to life and personal liberty. This article has been liberally interpreted by the Supreme Court to include some of the rights not mentioned in the Constitution. But the Supreme Court says that these rights can be enjoyed by the people. For instance, the right to live with human dignity, not mentioned in the Constitution. But Supreme Court means that right to life and personal liberty includes the right to live with human dignity, the right of livelihood, the right of the pavement dwellers, the right of the bonded laborers. These rights have been recognized by the Supreme Court by its liberal interpretation, although there is no mention of these rights in our Constitution. Fourth, the Supreme Court as the interpreter and custodian of our Constitution. Our Constitution is regarded as the supreme law of the land. So any ordinary law passed by our parliament or state legislature or any executive action must be in conformity with the Constitution. If it is not, if there is found to be inconsistency between the legislation or the executive action with the Constitution, then the executive action or the legislation will be invalidated by the Supreme Court. This is called Supreme Court's power of judicial review. That means the Supreme Court has the power to review any legislation, to review any executive action, and if these are found to be inconsistent with the Constitution, then the executive action and the legislation will be declared null and void by the Supreme Court. This is called Supreme Court's power of judicial review, by which the Supreme Court interprets the Constitution and acts as a custodian of the Constitution. Now, generally speaking, in a parliamentary systems like India, there is weaker traditions of judicial review. Judiciary seems to be not very important. On the contrary, the parliament is given more prominence in a parliamentary setup. So if a verdict goes against the executive, the parliament in a parliamentary setup like India can enact a new legislation in response to the verdict of the Supreme Court, in order to tide over the difficulties that was created as a result of the Supreme Court judgments. So it happened very often, particularly during the first 17 years, that the parliament passed a legislation the Supreme Court found it to be inconsistent with fundamental rights or inconsistent with the Constitution, Supreme Court invalidated that legislation. Naturally, in response, Parliament again amended the Constitution, and Parliament's unlimited amending power was acknowledged by the Supreme Court, particularly during the first 17 years in two well-known cases. One is Shankari Prasad versus Union of India, 1951, and Sajjan Singh versus State of Rajasthan, 1965. But subsequently, particularly since 1973, as a result of the judgment of the Supreme Court, in the Keshavananda Bharati versus State of Kerala case, the position has substantially changed. Supreme Court now acknowledges that the Parliament has unlimited power to amend the Constitution. But at the same time, Supreme Court expresses the view that there are certain essential features of the Constitution which the Supreme Court term as basic structures of the Constitution. These basic structures cannot be amended. The basic structures you cannot amend the Constitution in such a way that it destroys the basic structure of the Constitution. It destroys the very fabric of our constitutional setup. So the Supreme Court, by inventing the doctrine of basic structures, put serious limitations on our Parliament's power to amend the Constitution. Naturally, P.B. Mehta, Pratap Bhanu Mehta, raises a point, then who is the most important? Who is the final custodian of the Constitution? He says it is very difficult to answer the question because there are two competitors. On the one side, Parliament is of the opinion that it is the custodian of the Constitution. But there is another claimant that judiciary is the actual custodian, final custodian of the Constitution. So it is very difficult to point out who is the real custodian, according to Pratap Bhanu Mehta. But according to Granville Austin, another authority on the Indian Constitution, there is no doubt that the Supreme Court is the real custodian of our Constitution, the logical custodian of our Constitution. This is the view of Granville Austin, another noted authority on the subject. Finally, as already pointed out, Lavanya Rajamani and Argho Sengupta in a recent article have drawn our attention to the new kind of role played by the judiciary, particularly the apex court, that is the Supreme Court. That means the Supreme Court as legislative avatar and the Supreme Court as executive avatar. This new kind of role can be played by the Supreme Court because of the lack of legislation in different spheres. For instance, they point out that there is no law regarding adoption of Indian children by foreigners. Naturally, there is always scope for exploitation of children. In that case, the judiciary has to step in, and judiciary in fact stepped in following a public interest litigation known as Lakshmikant Pandey versus Union of India, 1987, in which the Supreme Court gave certain directions. These directions have to be followed while adopting Indian children by the foreigners. So, inter-country adoption of children, this matter was taken up by the Supreme Court, and Supreme Court issued certain directives. These directives were treated as laws, although the judiciary in any country cannot be considered as a legislature. In this case, the directions issued by the Supreme Court, for lack of proper legislation, these directions can be treated as law. Similarly, in 1997, a case was taken up by Supreme Court in a public interest litigation, Vishaka versus State of Rajasthan. Here, the Supreme Court addressed the issue of sexual harassment in workplace. And similarly, for lack of proper legislation, the Supreme Court had to issue different directives. And these directives are considered to be laws all over India in terms of Article 141 of the Constitution. Finally, the Supreme Court is functioning like an executive. According to Rajamani and Sengupta, they say that for good governance and public accountability, certain institutions like CBI, Central Bureau of Investigation, CVC, Central Vigilance Commission, Enforcement Directorate, ED, these institutions have to be given independent status so that they can act independently of executive control. And if they can do that, there will be the possibility of good governance and public accountability. Finally, again I shall refer to the observation of Pratap Bhanu Mehta when he says the Supreme Court has by and large played a significant and even a pivotal role in sustaining India's liberal democratic institutions and upholding the rule of law. So let me sum up what I have already discussed. That is, the Supreme Court over the years has been playing a kind of traditional role as played by the highest judiciary in other countries. Our Supreme Court is a federal court. Our Supreme Court is the highest court of appeal. Our Supreme Court is the protector and guarantor of fundamental rights. And our Supreme Court is the interpreter and custodian of the Constitution. And moreover, recently the Supreme Court has been playing the role of a legislative and executive avatar. And finally, the Supreme Court tries to, over the years, the Supreme Court tries to protect the democratic setup and the rule of law in our country.